So thank you, Michael. Thank you to all the organizers for inviting me to this conference. This is quite a treat for me. I'm a lawyer. I don't do these kinds of conferences, so it's very exciting. Thank you to Roberta, Elder Roberta, for welcoming us to the unceded Coast First Nations territory. I am looking forward to speaking to you about the Cambie Surgeries case, primarily because the submissions in that case ended last week, and after I finish with you guys, I don't have to talk about this case for at least a few months. So that makes me very happy. It's been a very all-consuming case. So what is this case all about? First of all, let me give you the Government of Canada disclaimer. I'm here as an individual. I'm not here representing the Government of Canada in an official position, so please, these are my opinions, my words. All right, what's this case about? It's a constitutional challenge to certain provisions in the Provincial Medicare Protection Act. The trial started in September 2016, so 3.5 years ago now. There were many adjournments along the way that dragged it out. And I'm sure most of you are familiar with the Medicare Protection Act. That is the provincial legislation that governs the provision of payment by the Medical Services Commission to doctors who are enrolled in the Medical Services Plan in British Columbia. And they get that payment in return for providing medically necessary services to British Columbia residents who are enrolled in the plan. When an enrolled physician provides a medically necessary service, the physician is entitled to submit a claim to the plan for the amount that is set out in the fee schedule. Now, the purpose of this act is to preserve a publicly managed and a fiscally sustainable healthcare system for British Columbia, in which access to medically necessary care is based on need and not an individual's ability to pay. That purpose, of course, also accords with the overarching purpose of the Canada Health Act. The Canada Health Act is there to ensure that Canadians have universal access to insured healthcare services on an equitable, prepaid basis. So again, on the basis of need, not the ability to pay. And in fact, in every province and territory, Canadians have a statutory entitlement to receive medically necessary services and hospital services that are determined to be medically necessary without charges at point of service. So the plaintiffs in this case want to strike down several provisions of the Medicare Protection Act, primarily so that doctors in British Columbia can offer patients expedited access to medically necessary health care in return for a fee. They've also brought this claim so that patients who are medically insurable or who are able to afford duplicative private insurance coverage will be able to recoup some of their cost of these medically necessary services from private insurance. So on the screen here, you'll see there are 3 prohibitions that are at issue in this case. The first is the Act's prohibition on duplicative private insurance. So this prohibition does not allow individuals who are covered by the Medicare Protection Act to purchase private insurance to cover medically necessary services that are already covered by the Act. You can't purchase private insurance, for example, to cover your knee surgery. This is similar to the provision that was at issue in Chihuly. The second prohibition that's being challenged in this case is the prohibition on extra billing and user charges. This prohibition in the Act does not permit doctors who are enrolled in the public plan to charge individuals who are covered by that plan for medically necessary services. In the BC legislation, the prohibition only mentions extra billing, but it's actually broad enough to include what would be considered user charges as well. So essentially, there can be, under this Act, no point of service charges for any medically necessary services provided by enrolled physicians. This is an important point. That prohibition accords also not only with the objectives of the Canada Health Act, but it's also necessary in order to avoid deductions to the Canada Health transfer payment. That is the annual cash contribution that the federal government makes to each province and territory for their healthcare spending. So the Canada Health Act establishes the criteria and the requirements that provinces and territories must fulfill in order to ensure that they get their full share of the Canada Health transfer. And a primary requirement under the Canada Health Act is that extra billing and user charges must be prohibited with respect to medically necessary insured services. That's the only way that a province will be able to obtain their full share of money under the Canada Health transfer. So a province, of course, could choose not to have such a prohibition, but then there would be financial consequences for that province. A point that's often overlooked in the media coverage of this case is that unenrolled doctors are not subject to the prohibition on extra billing and user charges. So if a doctor in British Columbia wants to charge for a medically necessary service, they can do so as long as they are not part of the public plan. So you need to de-enroll. If you do that, then at least from Health Canada's perspective, there's no extra billing or user charges occurring. The province would not be subject to deductions to their CHT payment when those types of doctors are charging for services. And then you see on the slide that the third provision that's at issue, and this is actually not an express provision, this is a de facto prohibition on dual practice. That's also being challenged by the plaintiffs. Dual practice occurs, of course, when an enrolled physician is providing insured services both in the public system and on a privately paid basis at the same time. And all provinces and territories effectively discourage this type of practice through a combination of legislative provisions, including the prohibitions on extra billing and user charges. So what this means in these provinces and territories is that physicians must participate either in the public plan or entirely outside of it. And this prohibition, as I said, is de facto because there are no provincial statutes, including the Medicare Protection Act, that contain any express prohibitions on dual practice. It's really the design of the legislative schemes that has the ultimate effect of discouraging this. So what the corporate plaintiffs in this case really want is to be able to simultaneously provide medically necessary services in the public system and in their own clinics for a fee. They want to be able to engage in dual practice, and right now what is standing in the way of that primarily is the prohibition on extra billing. So then who are the players in this case? I've mentioned there are corporate plaintiffs. There are two of them, the Cambie Surgeries Clinic and the Specialist Referral Clinic. Cambie Surgeries, most of you will be familiar with. That's the corporate name for the Cambie Surgery Center. It's located in Vancouver. It's one of the largest private medical clinics in British Columbia. I was Googling them just to get this right. 6 operating rooms, 7 recovery beds, 6 private overnight stay rooms. There are dozens of surgeons who are affiliated with the Cambie Clinic, and they are all, to my knowledge, enrolled in the public plan, and they also provide surgeries at the Cambie Clinic. Then the Specialist Referral Clinic It opened in 2002. It has 50 specialist doctors who are affiliated with that clinic, and as the name suggests, individuals can go to that clinic for independent medical and surgical assessments and second opinions by specialists who then just provide them to the individual. Now, Dr. Brian Day is the president of both the Cambie Surgeries Corporation and the Specialist Referral Clinic. He's filed numerous affidavits in this case, and he testified in court as the representative of the corporate plaintiffs. I'm sure that all of you are familiar with Dr. Day. He is a very outspoken advocate for private health care in Canada, and he is the driving force behind this lawsuit. There are also 4 individual named plaintiffs. Each of these plaintiffs were engaged with the private system in some way, either by obtaining diagnostic services or, so like MRIs, colonoscopies, or they obtained surgery for a fee at a private clinic, and these would be surgeries for medically necessary services. Each of these plaintiffs testified that they faced excessively long wait times in the public system and that they were harmed by that waiting, both physically and psychologically. So then we come to the defendants. The defendants in this case, the primary one, of course, is the Attorney General of British Columbia. It's British Columbia's legislation that's at issue, so they are the primary defendants. They have, of course, been involved in this case from the very beginning, which, as I understand, actually started way back in 2009 when the statement of claim was originally filed. The other main defendant in this case is the Attorney General of Canada. That's, of course, who I work for. We came relatively late to this wonderful tea party. We were not a named defendant in this case, and of course we would not be because there's no federal legislation that's actually being challenged in this case. The plaintiffs have not challenged any provisions of the Canada Health Act in this case, only the provincial legislation. However, as the Attorney General of Canada, we are always served with what's called a notice of constitutional question anytime there's litigation involving a challenge to either provincial or federal legislation. So Canada is always made aware of that. And when we are made aware of that, we are also given the right to intervene in such a case if we so choose. So that is exactly what we did. The Minister of Health at the time, this was in February of 2016, was Jane Philpott, who decided that this was an important case that could have implications for Medicare regimes across the country. So Canada was instructed to intervene. And our role has essentially been to support British Columbia's position, and I'll explain in a minute that we've done that through the filing of some additional evidence and also through our legal submissions. Now, there are also 3 other intervener groups who are part of this litigation. The first is the British Columbia Anesthesiologists Society. They are a voluntary organization that represents the anesthesiologists in the province. They filed 3 affidavits containing factual information about the experiences of BC anesthesiologists in the planning and the delivery of health services in BC. They argued that the public's access to anesthetic and surgical care in BC is not reasonable. Even, they said, for emergency surgeries. They said that patient care guarantees ought to be implemented, and they also argued for increased funding to secure more anesthesiologists in the province. It was at times difficult to ascertain with whom they were aligned, but generally they were aligned with the plaintiff's position. The patient interveners, that's the second group. The patient interveners were a group of patients who claimed to have experienced firsthand the perverse incentives and the resulting harms engendered by dual practice and extra billing. They became involved in the litigation following their efforts in conjunction with the BC Nurses Union to hold the provincial government accountable and ensure that the provisions of the Medicare Protection Act, including those prohibiting extra billing, were actually being enforced in the province. Each of these patient intervenors filed affidavits outlining the harms that they had encountered by engaging with the private provision of medically necessary services. So they, of course, were aligned with BC and Canada's position in the case because they sought to show that there were significant problems with allowing individuals to buy their way to the front of the line. And then there were the coalition intervenors. The coalition intervenors consisted of patients, individual doctors, and two organizations, the BC Health Coalition and Canadian Doctors for Medicare. And in addition to making legal submissions, they also were granted permission to put two expert reports before the court. One from Professor Marie-Claude Prémont, who provided her opinion on the impact of the Chihouli case in Quebec, and Professor David Himmelstein, who provided an opinion on the similarities and differences in the Canadian and the U.S. healthcare systems and how the plaintiff's case, if it was successful, would impact the Canadian system. They were very strongly aligned with BC and Canada, and their primary argument was that the provisions were necessary because they were what was allowing all British Columbians to have equitable access to essential medical services based on need, not ability to pay. Okay, so now we're going to get into some of the more technical legal arguments in the case. The case involves three sections of the Canadian Charter of Rights and Freedom. The first is Section 7. You see that up on the screen. Section 7 says, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So the plaintiff's claim under Section 7 was that the provisions of the Medicare Protection Act that they were challenging engaged their rights to life, liberty, and security of the person because those provisions caused them physical and psychological harm by preventing them from accessing faster medical and surgical care in private clinics. That's the essence of their Section 7 claim. It was that wait times in the public system were unreasonable, and because of this, they should be permitted to choose to obtain their surgeries for medically necessary services in private clinics. Under Section 7, a plaintiff has to establish three things. First of all, they have to show that they have actually been harmed, such that their right to life, liberty, and security of the person has been triggered. So the plaintiffs in this case had to show that they had endured physical or psychological suffering related to being on wait lists. Secondly, plaintiffs have to show under 7 that the legislation they're challenging is actually the cause of those harms. So in this case, the plaintiffs needed to show that the prohibition on duplicative private insurance and the prohibition on enrolled doctors with respect to extra billing was the cause of their suffering. So these prohibitions were what were preventing them from accessing the care they needed. And then finally, under Section 7, a plaintiff has to show that the effects of the legislation are not connected to the objectives of the legislation. That's the principles of fundamental justice part of Section 7. So in this case, the plaintiffs had to show that the restrictions on their rights, their life, liberty, and security rights, were arbitrary or overbroad. They had to show there was no connection between these restrictions and the objective of the law. So the plaintiffs said the objective of the law was to preserve a viable public health care system available to all regardless of ability to pay. So they needed to show that the prohibitions on duplicative private insurance and on extra billing were not connected to or in line with those objectives. And this is kind of a hard concept to grasp in many ways. So a very simplified example of this is from a different context. If you have a driving law whose objective is to prevent accidents, and a plaintiff challenges that law and is able to show that that law actually causes or contributes to more accidents, then that law would be arbitrary or perhaps overly broad. The effects of the law would not be aligned with its objectives. So that's what the plaintiffs needed to show here. They also brought a claim under Section 15 of the Charter. Section 15 is the equality provision of the Charter, and a law will be in violation of Section 15 if it imposes unequal treatment on the basis of enumerated or analogous grounds. So the enumerated grounds, as you see in the text of Section 15, are set out there. So race, national or ethnic origin, and so forth. And then over the years, the Supreme Court of Canada has also found there are several analogous grounds under Section 15, like citizenship, sexual orientation, and marital status. So again, as with many legal tests, there are 3 stages to the Section 15 analysis. The first stage is the plaintiffs have to show that the law they're challenging is creating a distinction between individuals. Then they need to show that distinction is based on one of those enumerated or analogous grounds. And then they have to demonstrate that the distinction perpetuates disadvantage, i.e. that it's discriminatory. So in Cambie, the plaintiffs argued that the effects of the laws they were challenging were discriminatory because in their view, these laws prohibited access to private treatment for many BC residents, but it exempted other BC residents from this restriction. So those who were, for example, covered by the workers' compensation scheme, the plaintiffs alleged they got faster care. Worker status, as you see under Section 15, though, is not a protected ground. So the way that the plaintiffs tried to get around this is to tie that claim into age and disability, so that they said that the laws were discriminating against some people because of their age, they cannot or they do not work, or because of mental or physical disability, they can or do not work. So that's how they tried to tie it into Section 15. And then there's one more section of the Charter that always comes into play in any Charter analysis. That's because the way Charter analysis works is that the plaintiffs must establish that there's been some kind of a breach of one of their Charter rights, and then under Section 1, the government is entitled to justify that breach of their rights. So the test under Section 1 requires the government to demonstrate that the law has a pressing and substantial objective, and that the means chosen by the law are proportionate to its objectives. So laws that aren't rationally connected to their objectives, or laws that have a greater impact on rights than is reasonably necessary to achieve the objectives, or laws that have negative consequences on rights that are not outweighed by the benefits achieved by the law, will not be justified under Section 1. So in Cambie, the plaintiffs argued that permitting a private treatment option would further the objective of preserving the public system, because private options would take some people out of the public system, thereby freeing up space in that system, shorter wait times, better access for those who remained within the public system. Plaintiffs also argued that a parallel private system could easily coexist with the public system, and that there would be no consequences for the public system that would be negative. And they also said, well, if there were negative consequences, the government could always regulate with respect to those consequences and ensure that they were minimized. So then briefly, the defendant's response to all of these legal arguments. With respect to Section 7, our first argument was, well, actually the plaintiffs haven't demonstrated that they've been harmed. In fact, the evidence showed that waiting for their treatments was due to failures on the part of their doctors to either identify the urgency of their situation or they failed to explore having the treatments provided by doctors who had a lot shorter waiting times. We also argued that these particular provisions in the Medicare Protection Act were not the cause of the harms, because we said these laws are not what's responsible for creating wait times or wait lists. In fact, the evidence showed that the existence of wait times is an extremely complicated matter, and that wait lists would either remain the same or potentially get worse if the plaintiff's claim was successful. So therefore, it cannot be that these provisions are the cause of their harm. We also argued that the plaintiffs fundamentally misunderstood these prohibitions. At least from Health Canada's perspective, the practice that would be offside in terms of extra billing would be only if an enrolled doctor billed eligible residents for any point of service charges for medically necessary insured services. That's what would be offside. But there's nothing offside of the Canada Health Act if an unenrolled doctor, someone who elects to opt out of the public plan, there would be nothing offside if that doctor charged eligible residents for these same services, because that doctor is no longer part of the public plan. The plaintiff's model, though, was seeking to mix the public and the private together by permitting enrolled doctors to charge patients for medically necessary services. Those services would still be occurring within the public plan, so that would essentially allow certain individuals in the public plan to buy their way to the top of the public queue. With respect to Section 15, the defendants responded to the discrimination arguments, first, of course, by pointing out that there are no distinctions that are created here. The comparison of a provincial health care regime with a workers' compensation scheme was entirely inappropriate. They're two completely different sets of legislation. They have different legislative schemes. They have different procedures, different priorities. And regardless, it's not like someone who's in the workers' compensation scheme can simply pay their way to the top of that scheme either. It is still all regulated as a public plan. And then with respect to Section 1, we focused a lot on how the court should really employ a deferential approach to its considerations under Section 1, because here we're dealing with a regulatory regime that, as all of you know, involves very complex social issues, and it's about balancing multiple competing interests. So the legislation is in service of these complex policy goals, and so we said the court should not lightly interfere with the government's choices in this respect. Now, I have to say we're not usually successful when we make those kinds of arguments before a court, but in this case, I actually think it resonates quite well. We also argued that under Section 1, the government doesn't have to put forward conclusive scientific proof that would justify the legislation. Instead, all we need to do is show that there are some studies that support the government's position such that it shows the legislation is needed. They show that the government is reasonable in apprehending that there would be harms that would occur if these provisions of the legislation were gone. Now, in Cambie, there was a certain amount of conflicting expert evidence on the potential impact that striking down the legislation would have on the public health care system. But we argued that just because there's conflicting evidence doesn't negate the fact that there remains still an abundance of expert evidence from Canada and around the world that does highlight the potential harms of striking this down. So then let's move to what the evidence was. This is the last portion of my talk today. There were two basic types of evidence presented, as there are in pretty much any case, evidence from lay witnesses and evidence from expert witnesses. The lay evidence, as you see here, there were four basic types of lay evidence. Patient witnesses testified for both sides. Obviously, the individual named plaintiffs testified. They were all patients with various ailments who testified about the impact of waiting and about seeking private care. The plaintiffs also put forward a number of other individuals who are not named plaintiffs. They were also patients. They described similar situations of being stuck on the public waiting lists and the impact that that had on them. On the other side, the AGBC and several of the intervenors, the patient intervenors in particular, put forward patient witnesses who told the exact opposite story. They told a story about all their negative experiences with the private pay system, and they talked about things like how specialists, when they saw them, would tell them they had very long waiting lists in the public system, but if you just pay me a fee over here at Cambie, I can do your surgery tomorrow. There were also a number of doctors who testified in the case. Primarily, they were from the plaintiffs. They were almost invariably affiliated with either Cambie or the specialist referral clinic. So they were usually shareholders in those entities, and they testified with respect to the length of their own wait times and also how wait times had worsened over the years, and that they didn't have any more time available to them in public hospitals, that their operating time was taken up there. Then there were the corporate representatives. That was primarily Dr. Day, who, as I said, filed a number of affidavits. He testified in open court and he was cross-examined. I'm sure many of you read the media accounts of that. There were government witnesses from both Canada and British Columbia. We tendered evidence, for example, with respect to BC's healthcare system, including the roles of the Ministry of Health, the Medical Services Commission, and so forth. Canada tendered evidence from two Health Canada witnesses who spoke to the development of Medicare in Canada and also to the development of the Canada Health Act, its objectives and its policies. Then we turn to the expert evidence, and there were three general categories of experts in this case. We had healthcare policy and economics experts. There were about 17 experts who gave evidence on these issues, 9 of them for the plaintiffs, 8 of them for the defendants. They provided information such as the complexity of health systems generally, the impact of duplicative private insurance on healthcare, the need for government regulation with respect to private insurance, whether or not allowing dual practice would have an effect on the overall fairness of the public system, whether or not dual practice would likely reduce or increase wait times in the public system, and so forth. So the trial judge in this case is going to have to give, decide on the weight that he is going to give to each of these experts' evidence. That will, of course, be based on the qualifications of those experts, the credibility that they had when they were testifying, their level of independence. I mean, are they just paid advocates for one side or the other, or are they truly experts in their field? The trial judge will also have to consider the level of rigor with respect to their methodologies. So are their methodologies sound? Are their opinions grounded in empirical evidence? The empirical evidence tends to always be given more weight than studies that are based on qualitative evidence. So there were also experts like Michael Law, in fact, who provided information to the court about how to assess methodologies and how to make sense of all of the types of methodologies being used by these various experts and whether or not they were sound or not sound. Secondly, we had a lot of information on international comparative healthcare systems from, again, various experts. There were a whole range of jurisdictions discussed, but I think it's fair to say the most of the evidence here went to the situations in the United Kingdom, Ireland, New Zealand, Australia, and Quebec. So that's where we had most of the evidence from. And then finally, we had many experts who discussed the medical effects of waiting. So these experts were talking about issues relating to wait lists, benchmarks, and then again, the effects of waiting. There was general agreement among these experts that wait times provided a very imperfect measure of the performance of a public health care system. But with respect to the medical effects of waiting, there was considerable disagreement among the experts on whether waiting has any long-term effects like increased mortality or the deterioration of the underlying condition. And so again, the judge will have to weigh all of this competing evidence, and it's a very formidable task. So finally, what to expect? The timing of this decision. I would think at least 3 to 6 months, given the volume of evidence. I would have said even longer than that normally, but because there have been so many adjournments in this case, I anticipate that the trial judge had that period of time to actually begin to assemble portions of the decision. So we can expect to see it, I think, within 6 months. And then appeals. This is one of those cases where you can absolutely predict that no one's going to be happy with the outcome regardless. So somebody's going to be appealing. And that first, of course, goes to the British Columbia Court of Appeal. And then if leave is granted, it goes to the Supreme Court. That's 2 to 3 years, at least. So I have some fun times ahead of me. Anyway, thank you, everyone. I appreciate it. Stay up here. Let's go down.